Welcome to Real Estate IQ Wisdom for Smart Moves. We will explore the insider secrets tailored exclusively for Silicon Valley home buyers, sellers, and investors, arming you to conquer the unique real estate landscape. So, without further ado, let's dive into this exciting conversation. Today, we welcome Maggie LaBranch, an accomplished associate attorney specializing in estate planning, trust, and probate law. With her deep expertise and empathetic approach, Maggie guides clients through the intricacies of estate planning, ensuring their real estate assets are well managed and their familial wishes are honored. Thank you to our sponsor, TradeMyHome.com, for their community commitment and for making this podcast possible. In today's episode, we delve into a pressing issue. 60% of Americans don't have an estate plan, risking efficient management of their real estate assets. With U.S. median home values soaring over 13%, homeowners face increasing estate tax challenges. Moreover, as 40% of adults belong to blended families, the absence of clear estate plans complicates inheritance, making tailored estate planning more crucial than ever for real estate owners. Our host today, Shared Gupta, is a real estate broker in Silicon Valley and brings a wealth of life and professional experience to his role as a podcast host. The following content is only for informational purposes. Please consult a licensed consultant for your specific situation or if you need any specific legal or tax advice.
Maggie, welcome to the show.
Thank you for having me. I'm glad to be here.
What are some typical complications which arise in a probate?
So one of the first things you have to consider is when you're in court, the court is going to be monitoring everything that the executor is going to be doing. So the executor has to go to court and they have to get permission from the court to even act as the executor. Then they have to get permission to sell the property. So they have to go to court and get an order to sell it. So they have to know who the real estate agent is, what the listing price is. And if they deviate from that, then they have to go back to court and get permission to deviate from all of that. That takes time. It's money you might be wasting. The other thing you have to consider when you think of real estate, especially around here, is maybe it's not selling it as is. What if you have to put money into the property to get a little bit more out of the property? So then you might have to get permission to be able to spend some of the assets in order to do that. Whereas if you had a trust, you're not having to go to court and be monitored by this. You just have to be reasonable about what these expenses are. Or you just ask the beneficiaries, hey, I'm looking at spending $50,000 based on my realtor's recommendation. Do you guys agree? Because he says or she says we're going to get $200,000 more in profits out of this. But if you go to court, you have to justify that in the beginning. Why am I spending assets to make money? Sometimes the court says that's not important. Just get rid of it, get it off your hands. And they're going to say, no, you can't spend a little bit of money that way. Other things to think of, what if you have renters in there? What if they don't leave? Now you're in court trying to get rid of the renters because they're not leaving because they know somebody died. So now you have to fight with that. Where do you put the rental income that comes in? What if it's held in an LLC? So then that adds another level of complications to it. How do you keep the homeowners insurance going? Do you have access to bank accounts to pay all of these bills? What if you have a situation where you have two or more beneficiaries and they can't agree on how to divide it? One of them wants to keep it, one of them wants to sell it, so now you're in court fighting about it in a probate. Whereas the trust generally says it's pretty clear, and who gets to make that decision? And now you're not in court, you're not fighting about it, and the judge isn't making the decision, right? The family's already decided what that looks like and who gets to make that decision.
And how can homeowners ensure that their real estate doesn't end up in probate?
The biggest thing is to have the trust, which we talked about. Real property in the state of California, you're going to want to have a trust because there's no way to add a beneficiary to the property. The most important thing, though, is to make sure that you've actually deeded the property into the name of the trust. Just listing it on your schedule is not enough to avoid probate. You actually need to record a deed that transfers the property from you as the owner to you as the trustee of your trust. If that's not recorded, it's not going to avoid anything. So a lot of times what I see is over time you refinance, right? You want to take some money out and the refinance company will take the property out of the trust. I don't know why they do it, but a lot of times they do that and they don't put it back into the trust.
Oh my God.
So it's important for you to just over time make sure that it's always gotten back into the trust to avoid probate. that's the biggest thing. So you don't want to ever prepare the deed yourself. It's worth paying a couple $100s to have an attorney prepare it or have a title company prepare it versus doing it yourself, because I've seen a lot of DIY deeds that don't help, and then you end up in court anyways trying to put it into the trust because you haven't done it properly. The easiest way to tell, or just remember if you have it in the trust, is to look at your property tax bill, because it will come in and say trustee of or trustee or something like that. That's the easiest way to say, like, oh my gosh, I don't remember if I ever put it in the trust. It'll automatically say on the property tax bill. So that's the easiest way to find out.
And what are some common legal complications which families face when they inherit real estate?
One of the common things that I see most often is that is the only asset, or the biggest asset in the estate. And so families are often faced with having to satisfy a division amongst the beneficiaries or gifts to people out of this asset, and one person wants to keep the house. Or maybe it's siblings and they want the parent-child transfer under Prop 19, and they can't buy out the other sibling because then half of the property will get reassessed. So they have to do it in a different way. There are legal ways you can get around these. It's completely legal, but you have to do steps along the way to make sure that happens so that you can capture the Prop 19 and do it in a specific way. The other thing to think about is, and I see this a lot with families, is they think, oh, you know what? I'm going to add my son, my daughter, my whoever that is to property today so that when I die, it's an easy transfer. You know, Maggie said if you hold it in joint tenancy, the surviving joint tenant owns it. One of the things they're forgetting about is taxes, because what'll happen is you don't get the step up in basis for that part of the property of the person who passed away. They're inheriting it. If they turn around and sell it, they're going to get hit with a capital gains tax that they haven't considered. So it's always better to inherit property, leave it to the beneficiary versus adding people to title today. If a client calls me and says, I have decided to add my son to my property, I'm always like, no, please don't do it, because it's better for them to inherit it tax-wise. We can set up a special trust for them so that they're inheriting it in a trust, which gives them more protection that they wouldn't get if they were just added to title. So there's all of these little things that you aren't thinking about when you're thinking, oh, it'll just be an easy way to avoid probate. But there's all of these other things you haven't considered. Taxes. You can give them asset protection, which protects them over time. You haven't thought about maybe they want that Prop 13 low parent tax to be able to transfer to them, which now is much more complicated than it used to be. So all of these little things will be helpful if you came and saw an attorney and just asked these questions that they could help resolve for you today, versus waiting until you've passed away and now we might not be able to undo it.
How do community property law in California affect those couples who are married and affect those couples who are living as partners?
It really boils down to taxes. The IRS gives preferential tax treatment to those couples who are married versus couples who are not married or just unmarried people. If you're unmarried, I'm sorry, you're just getting the short end of the stick. Married couples get the benefit of tax treatment because each person gets a step up in basis at death. So if it's community property, you get a double step up. You get the benefit of both spouses passing away, so that if you turn around and sell the property, then they get the full step up. They're not paying the capital gains tax. So let me do an example. It's an easy way to do an example. So let's say a couple purchases property together. They're married for $100,000. When the first spouse dies, say the property is worth $1 million. The surviving spouse can turn around and sell the property the next day. That $900,000 of gain is completely eliminated if they held it as community property. If they don't sell it, they turn around and pass away, and now the property is worth, say, $1.5 million. Now the kids or whoever's inheriting it at the $1.5 million, that $1.4 million is completely eliminated because they get the double step up. So it's a benefit for the kids or whoever's inheriting as well to get the double step up. Now, if you're domestic partners and you're registered domestic partners, just like I'm not just treating myself as domestic partners to get health insurance kind of domestic partners, but you're actually registered in the state of California. The state of California treats registered domestic partners just like a married couple. However, the federal government does not.
I see.
So there is a huge distinction tax-wise in terms of the treatment for registered domestic partners. They don't get the step up. They don't get the benefit of that. I've tried to convince many couples to get married for that benefit, just tax-wise, to take advantage of that. So there is a difference. For all intents and purposes, you're treated as being married in the state of California. You go to any other state or the federal government, guess what? You're treated just like you're not married. Being married, one of the many benefits or few benefits, depending on how you look at it, is unfortunately taxes. But that's a huge one, is the capital gains tax.
A typical problem homeowners have when wanting to buy a new home is whether to sell first or buy first. Either way is risky. When ready to look for a new home, TradeMyHome.com, powered by Your Home Sold Guaranteed Realty, offers an upfront guaranteed cash offer on your current home. Are you moving in the next 3 to 6 months? Text PAIR to 408-740-7400 for a free and no obligation professional equity appraisal report. For more information, visit TradeMyHome.com or call 408-740-7400. Remember, at TradeMyHome.com, your home is sold guaranteed or we'll buy it.
Can you discuss the estate planning challenges for the LGBTQ community?
The good thing is we live in the state of California, and there's a lot of protections now, and the federal government is also recognizing marriages within the LGBTQ plus community. So the good thing is there aren't a lot of special considerations that would be treated differently than any other couple. Where you're going to see the distinction is when you are just a registered domestic partner, not the domestic partner where we're not treating each other, but it goes back to that registered domestic partnership, which is not recognized by the federal government. What you have to remember is, and this is any couple, it doesn't matter what your status is that if you don't have the documents to support you and you're in the hospital, you're at the bank, you don't have a financial power of attorney, you don't have a healthcare power of attorney, then they don't have to recognize you, whether you're a spouse, whether you're just a person standing there. You want to have the documents no matter who you are, because doctors don't have to take your word for it that you're the spouse, that you're this other person. So that's why it's really important to have those documents, so that if something happens, you're able to immediately access bank accounts, pay bills, make health decisions that you weren't able to. So it doesn't matter anymore, especially in the state of California, what your status is. What's important is that you're taking care and you're working on getting the estate planning documents to make it easier on your loved ones when it's really needed.
And how can first-time homebuyers incorporate their real estate into their estate plans?
The easiest thing to do is just to remember that you have one. So if you already have established a trust, then you can buy property, sell property in the name of the trust. So it's just remembering that you have one and giving that to the title company. That's the great thing. It's when you purchase real property and you don't establish the trust, that's when you're going to have a problem. Because if you're not married and something happens to you and you don't have a trust, then you're going to be looking at probate. If you are married and it's just the two of you, how did you hold title? Do you hold it as community property? Do you hold it as joint tenants? Is it tenants in common? Is there somebody else on title with you because you needed help with the loan? That's where it's going to get more complicated. So making sure you have a trust either already and then giving the title company the name of the trust, easiest thing to do. Otherwise, it's how do you then transfer the property into the trust? What does that look like? What is the ultimate plan? If you have somebody on title, are they going to also be holding their portion, or are they going to come off title? What does that really look like? So that's when you want to reach out to an attorney and figure out what is the ultimate plan here with the property if something were to happen to you.
What trends do you foresee in estate planning which could impact homeowners?
Fortunately, estate law hasn't really changed that much in the last 100 years. What is going to change over time is taxes. It's the big estate tax that's going to change. The gift tax might change. How much money you can give to your children each year or your beneficiaries or just anybody, that's what changes. So it all really boils down to taxes. What you're going to see is how couples structure their trust, how that looks, whether they have an A-only trust, it goes to the surviving spouse. Do they have an A-B trust where part of it goes to the surviving spouse and the other part is locked in an irrevocable trust for whatever reason? But a lot of it is going to boil down to what is the value of their assets, the value of their real estate holdings. What does that look like? If they do have an A-B trust, how do you structure it so you can capitalize on the estate tax, but also on capital gains taxes so that their kids are not paying capital gains taxes? You know, which properties go into which bucket? And so really, it's going to be a wait and see what happens with the estate tax. It's supposed to drop at the end of this next year and the end of 2024. Are they going to actually go back to the $5 million a piece? Are they going to keep it at the $10 million a piece? Maybe it'll just go away completely. We don't know. So it's important, if you do have a large asset portfolio, you have a lot of real estate holdings, those generally are going to go up in value, that you have to keep a pulse on what the taxes are going to look like. And that may impact the way you structure your trust, or if you have to do other advanced estate planning. That's really what you're going to be looking at, versus how do the estate laws change over time. It's really more about taxes.
What roles do attorneys play in real estate transactions, and when should homeowners contact you?
From my perspective, when I'm dealing with estate planning, it's really about making sure the deed, the title of the property is in the trust. So a lot of time homeowners will contact us to make sure that we're going to prepare the deed properly, to make sure it gets into the trust, because it's usually one of the larger assets. The other times we see it is if they're thinking, like I said, of adding someone to title or gifting property to their beneficiaries early before they pass away, which sometimes will happen. A lot of times when clients are looking to qualify for state assistance for skilled nursing care, for example, they may create an irrevocable trust to pull the asset out of their estate to help them qualify for medical assistance, to qualify for government assistance. That might be a time when they would contact us. When families are now looking to distribute the assets, they're going to do a trust administration, or now they have to do a probate, they would usually contact an attorney to assist with that process. And then we would help guide them along the way of what needs to happen, either in the terms of the trust or the probate. Our office doesn't handle disputes, litigation, or anything like that. But oftentimes families, they will fight over who's going to get what. They can't make an agreement. There's a renter that's there that won't vacate, or there's some condition in the property that's causing a dispute amongst maybe the buyer or the seller, or something in the transaction. And in that case, I would refer you out to either a real estate attorney or some other attorney who would specialize with the litigation aspect of it. That's when you would want to see an attorney a lot. It's just like anything else. You get a real estate agent because they're handling that. You're going to get a broker to help with the mortgage, something like that. So you want to tap into the resources around you to help you along the way, rather than just saying, I'm going to handle all of this myself.
And why should homeowners contact Maggie versus other probate attorneys?
What makes us so special, right?
What makes it so special?
Exactly. Our office, one of the things that makes our office really unique is that all of the estate planning that we do, the trust administrations that we do, are all done on a flat fee basis. So you know exactly what the fee is for any work that we do, and we don't ever send you a bill in the mail. So let's say, for example, you hire us, we create your estate plan. In a couple of years, you've reviewed it and you want to make some changes. You tell us what the changes are. You come into the office. We'll tell you what the fee is. You'll never get a bill that says, oh, by the way, it was 10, 15 minutes phone call. Here's what the bill is. So we don't have an hourly billing rate. All of our fees are flat fees. So if you have questions, you can call us. You can email us. You can come into the office and meet with us. We'll go over your estate plan. All of that is free. We want our clients to call or email us or ask questions so that we can avoid any issues that they may have in the future. We want them to call and ask those questions to avoid any problems in the future. A lot of the things that we do, a lot of other firms don't. We review estate plans that you already have, no charge. We'll review them. We'll go over them with you. If you want to make changes, it's a flat fee. We also do Medi-Cal planning, which is helping you qualify for the state of California to pay skilled nursing care costs. I know we didn't talk a lot about that, but that is another thing that our office does that a lot of other firms in the area don't do as well. And then a lot of our plans incorporate asset protection for your beneficiaries, which is how you can protect your beneficiaries for whatever life's going to throw their way. It's protection that you can't give yourself, but you can give to your beneficiaries.
Thank you so much, Maggie, for being part of our show today. It was a pleasure speaking with you. And let's stay in touch.
Great. Thank you for having me. It was a great time.
For the next episode of Real Estate IQ, featuring Peter Eberhardt, a former BMX champion turned real estate maven.
Well, it was unintentional from the start. I will say that. I was living in San Diego, and the cost of living was on the rise. BMX racing in general by nature is very expensive.
From racing in California's mountains to mastering multifamily investments, Peter's journey is a testament to determination and adaptability.
in the forefront of my mind, I started to look for ways to either increase my income or to decrease my expense.
Check out our full episode on Tuesdays at 5 o'clock Pacific and 8 o'clock Eastern on YouTube and Apple Podcast. Thank you for listening to the podcast and acknowledging the wisdom of smart moves in real estate in Silicon Valley. Please share this episode with a friend, subscribe, and leave us a review on Apple Podcasts or wherever you listen to podcasts at Real Estate IQ. Thank you to our sponsor, TradeMyHome.com, for their client commitment and for making this podcast possible. If you're considering buying or selling a home, visit TradeMyHome.com. Until next time, remember to stay ahead in the real estate game.